Okay, everyone, thank you for joining me. We are going over leaves of absence and paid time off during today's webinar. This is our second boot camp session. Last Friday, we went over wage and hour issues. So if you didn't see that, you can find that video on our website, hopefully within the next few days. And we'll go ahead and get started. Just my standard disclaimer, I can't give legal advice in this type of format. I need a lot more information about your specific situation in order to do that. Today, we're just providing general information about leave of absences and the law relating to those. So we're going to go through these topics today. What are the types of paid leave in California? We're going to list all of them. I think I've got them all. Then we are going to talk in more depth about these types of absences. Sick leave, the California Family Rights Act and its federal equivalent, the Family and Medical Leave Act, the FMLA. Pregnancy disability leave, which is treated separately from FMLA in California. The FEHA, the Fair Employment and Housing Act, and Americans with Disabilities Act, which do provide for some absences as an accommodation for a disability. Crime victim leave, which expanded this year. The other leaves of absence, just generally what they are and what they cover so that you're aware of them if they apply to you. And then just some brief mention about vacation and some of the requirements that trip people up. And then I do have one final slide, which is on wage replacement benefits that are offered through the state, like disability leave and paid family leave. We're going to start with the types of leave that we have in California. If you have me do your handbook, I include the ones that are applicable to your workforce, or if you're kind of on the edge between two different size categories, we sometimes include more. We start with the common ones, the big ones here on this first slide, but there's more than this. We have 3 slides of these. So paid sick leave, which is applicable to all employers in California, regardless of your size. The KinCare law still exists, and that is less applicable nowadays. But if you're offering more than the minimum of sick leave, then there are some requirements that you have to follow to allow employees to use that for illnesses of family members. I think most employers are doing that now, but still technically there. Leave for survivors of violence for the, I had this broken down into 2. So for employee, it applies to all. And then if you have 25 or more employees, there's extra protections for employees who have family members who are victims of violence. The California Family Rights Act applies to everyone with 5 or more employees. Religious accommodation applies to everyone with 5 or more employees. It's part of the Fair Employment and Housing Act. The Pregnancy Disability Leave Law is 5. Bereavement leave, reproductive loss leave, those are all 5. If you have questions, because you're on the line between 5 employees or 25 employees, each of these laws defines your payroll a little bit differently. Does it include independent contractors? Does it, how long do you have to look back to see how many employees are on your payroll at any given time? So if you have questions about those kind of specifics of how to calculate those numbers, that's outside of the scope of what we're doing today. We're doing more of a substantive discussion, but that is something that you want to be aware of and pay attention to make sure that you're actually counting your employees correctly. It would be a problem if you thought you had 19 employees and really you had 25. The Family and Medical Leave Act is the federal law, and it applies to those with 50 employees. Military leave law applies to everyone. California military leave applies to everyone. Spousal military leave is 25. Reserve emergency personnel applies to everyone. Civil Air Patrol, 15. Drug and alcohol rehabilitation leave, 25. School discipline, all. Family School Partnership Act, 25. Employee literacy leave, 25. Time off to vote applies for everyone. And I do have a slide on that. there are some restrictions on when you have to provide time off to vote, and jury duty has to be provided to all. That doesn't have to be paid. So a lot of employees will show up for the first day of their jury duty, which is a guaranteed leave of absence in California. But then when they tell the judge that they have a financial hardship because they're not being paid for their jury duty time, they're often then released from jury duty. Organ and bone marrow donation is much less common, but it's 15. And bone marrow donation, I have a slide on that too, because it's a little unique. So we're going to start with, does anyone, what I'm going to do in this presentation is ask at the end of each section if anyone has any questions, just to kind of catch those up. So if you have any questions about the list, let me know, but we are going to go through all of them in more detail. We're going to start out with paid sick leave. I'm looking off to the side here because that is where my Q&A box is. So the reasons you can use paid sick leave in California, we've had this law for a number of years now. I think a lot of people are familiar with it. It includes the diagnosis, care, or treatment of an existing health condition in certain family members. To obtain treatment or assistance or attend legal proceedings relating to domestic violence, sexual assault, or stalking, for an employee who is a victim of a qualifying act of violence, or who has a family member who's a victim of violence, and for an employee who is an agricultural employee who works outside to avoid smoke, heat, or flooding conditions created by a local or state emergency that prevent the employee from working. That's a new one this year. And also the crime victims leave category has expanded. So that's new this year as well. Now, who can take, or the employee can take the leave, obviously, but who can they take it for? Who can they help with a doctor appointment or a medical condition and receive paid sick leave for that? A child, a parent, a spouse, a domestic partner, grandparent, grandchild, sibling, or a designated person. A designated person was added a couple years ago, and that's someone who is related by blood but not one of the listed categories, or who their relationship with the employee is equivalent to a family member. And so this could be maybe a boyfriend or a girlfriend, or a surrogate parent, someone maybe a neighbor of the family who took in a child. Maybe that is someone who counts as in loco parentis, but it can be a lot of different people. It's not unlimited, however. Employees can be required to identify that person at the time they request the sick leave, and then to stick with that person for the next 12 months. So if they have a lot of boyfriends over the course of the year, and they could potentially be restricted to just that first one. And this doesn't require you to keep updating that designated person throughout the year. And then the child, I skipped over this. Child includes both a biological or adopted child, a foster child, a stepchild, a legal ward, or someone else to whom the employee is acting as a parent. Similarly, parent includes the inverse of those. Oops, sorry about that. So in 2024, the amount of time off increased. It used to be, oh no, now the gardener's coming. That's good timing for my neighbor. But hopefully you can still hear and that's not too distracting. So the time off used to be 3 days or 24 hours, and now it's 40 hours or 5 days. So that has to be updated in your handbooks. I know a lot of employers increased it, but then they didn't add it to their handbook. So you want to make sure you've gotten that caught up. And this has been clarified for us over the years. This is the one that is most generous to the employee. So if you have an employee that works a 10-hour day, then they would be entitled to the 40 hours or the 5 days. If you have someone that works a 12-hour day, then they're entitled to the 5 days because that's more hours. The accrual rate remains 1 hour of sick pay for every 30 hours worked. You can cap the employee's accrual at 80 hours or 10 days, so 2 weeks. And then there were some changes to those employees who were covered by collective bargaining agreements. There's a little bit more exemption for those if the CBA has the correct language in it. And then employees do not have to be paid out the sick leave when they leave employment or at the end of the year. But if you have an employee that leaves and then returns within the same year, their prior balance has to be reinstated. Oh, I added the new ag change twice, but that's the new law there. And then the sick leave is not paid at the employee's standard hourly rate. It's paid at the regular rate of pay. And so we talked about regular rate of pay in depth during last week's webinar, but that includes things like non-discretionary bonuses, shift differentials, production bonuses, commissions, piece rate pay. So if you are paying out sick leave and your employee receives anything other than their hourly pay, you need to make sure that you're paying the regular rate of pay correctly. The new sick leave law spells out some deadlines if you want to use a different accrual method than the 1 to 30. The employee has to have no less than 24 hours of accrued sick leave by the 120th calendar day and 40 hours of accrued sick time by the 200th calendar day of employment for their use. And that can be a calendar year, it can be the employee's anniversary date, it could be your fiscal year. It just has to be a consistent 12-month period for that employee. Employers can provide a lump sum of sick leave still, as we could in the past. There's requirements for that. 24 hours or 3 days available by the completion of the 120th calendar day, and no less than 40 hours or 5 days available by the 200th calendar day. The DLSE has put the Department of Labor Standards Enforcement, the Labor Commissioner's Office, has put up an FAQ and kept that updated. I've linked to it here. I do recommend checking that out. Employees are reading that. If you get a Labor Commissioner claim, that's what they're going to follow. This is what they say about lump sum policies or upfront policies. An upfront policy makes the full amount of sick leave available immediately at the beginning of the year, except for initial hires, where 3 days or 24 hours must be available for use by the 120th calendar day, and 5 days or 40 hours must be available for use by the 200th calendar day. So this is slightly different than how I interpreted the law, but this is what they are enforcing now. And so if you have any questions about how an employee might be trying to understand sick leave, that FAQ is a good place to check that out. Some cautions with regard to sick leave that you might want to be aware of. Attendance reward policies need to adjust to not penalize an employee, to dock points from them if you had it previously set at 3 days. It needs to go up now to carve out the whole amount of paid sick leave, the 5 days that's now required. You can't require your employees to find replacements. And I have seen recently some policies that don't require a replacement, but ask the employee to find someone else to complete their projects or do their work. I would caution you on that because that's a lot like finding a replacement. That burden is on the employer. The employee doesn't have to do anything to take their sick leave. Asking for impermissible documentation is another one. The sick leave law does not have a built-in requirement that the employee have to provide any documentation for the sick leave. So my recommendation, sorry, I had a cold last week and it's almost gone. So I have a little bit of sniffle. So the employee should be allowed, in my opinion, to take 5 days of sick leave before they have to turn in a medical note. Now, that would be different if you had some reason to believe that the request for sick leave was fraudulent or that there was some kind of abuse of your policy going on. But you would want to have some documented reason for requesting that before the sick leave runs out. Also, you can only require that the leave be taken in increments of less than 2 hours. So if an employee had a doctor appointment at 8 a.m., you can't require them to take a half day. You could require them to take 2 hours. That's the amount that the legislature felt was reasonable for you to have to cover, for example, find another employee. Fits in line with some of the other show-up pay statutes. But larger than that would be impermissible. And then if you're going to have a PTO policy that provides for time off for other reasons, it should be larger than the minimum sick leave law. So if you had a PTO policy that was 5 days of paid time off previously, that was probably okay because you had your 3 days for the statutory reasons under the sick leave law, and then 2 days at the employee's discretion for personal reasons. If you don't have any extra, then there isn't really room for the employee to use up those days for personal reasons. There's a couple questions. Let me see if let me just cover this last slide and then I'll answer the questions. Kin care requires that you allow the employee to use half of their sick leave for their spouse, domestic partner, parent, or child. So if you have a 2-week sick leave policy, you could technically follow the state law for the first 5 days and then have some kind of more restrictive usage policy for the second week, but it would still have to comply with kin care. I don't see anyone doing that. It's overly complicated. Okay, moving on to the next section. So let me answer some of these questions. If the employee receives 40 hours at the beginning of the year, if they return to work within 1 year, we would not need to reinstate sick leave. You would need to reinstate their balance. So if they had, I see what you're saying. I'm following now. If it depends on whether your year is a calendar year versus the employee's anniversary date. If it was their anniversary date, no, you would just reload another 40 hours. But if it was a calendar year, you would need to make sure that you met those minimums that are built into the law when you reload. So if they had a balance of 2 days left, for example, then you would need to make sure that they met these minimums when you reloaded their sick leave based on what they had previously. Another question, we require a doctor note after 3 days. Would you discourage this? Yeah, I would. The law doesn't provide for it. I know there's a lot of reasons that employers do, and 3 days is so common and it fit with the last law. But with this update, I think that you create some liability for yourself if you if you penalize an employee because they didn't bring a note and the law doesn't require the note. So what do you do with that employee when they don't comply is the question. On day 4, they say, I couldn't get in to see my doctor. I still want my sick leave. And, you should give them the sick leave. So what's the purpose of the policy if you aren't able to enforce it fully is the question. Okay. Any other questions about sick leave before we move on? The most common issue I see with sick leave is not paying it at the correct rate. Everyone, I think, for the most part, has got compliant policies with carve-outs for any attendance bonuses, but they don't always pay it at the regular rate of pay. Okay. Another question, would you answered. Would you require a doctor's note if 5 days have been exhausted? That's up to you, and it really depends on your workforce. If you have a very small workforce where you get a lot of information from your employees, then I don't see a lot of employers don't see a reason to require it. But if you have a large workforce and a very large amount of attendance issues, then after this runs out, you could ask for additional documentation, because any sick leave that you are providing beyond the 5 days, you could provide in a different format, or under a different type of leave, like vacation or like PTO. So it still has to comply with the rest of the laws we're going over. But yeah, you could do that if it was an issue with your workplace, I think, if it met the other requirements. Okay. The issue with medical notes that I have seen in the last few years is that it's hard to get them. So especially in Stockton, to get a doctor appointment is nearly impossible on a quick basis. And a lot of employees have to end up going to urgent cares to get those notes. There can be a significant cost to that for them. Or they just can't get an appointment at all. And so they don't come back with the notes. So I take that for what it's worth, but I have seen that be a problem for employees. Okay, the California Family Rights Act and the FMLA overlap, but they're different, and they've diverged more as the years have progressed. I break them out in my handbooks now separately, even if you have 50 employees, but not everyone does that. Some people still combine them. It's just preference. It provides up to 12 weeks of leave, unpaid leave, for an employee's serious health condition or the health condition of a family member. A serious health condition is an injury, illness, impairment, or physical or mental condition involving either inpatient care in a hospital, hospice, or residential medical care facility, or the most common, continuing treatment by a healthcare provider. That covers a lot of different things. It could cover a severe anxiety disorder. It could cover a diabetes, a seizure disorder, an acute illness like COVID, a lot of different things. So when your employee comes to you and says, I have this reason to be out for a very long time, or I have repeating appointments, they may be covered under the Family Rights Act, and you need to look into that and provide the proper notice. This also in California could be, and in federal law, could cover the birth of a child or to care for that child, what we commonly refer to as baby bonding. In California, pregnancy is separate, so baby bonding is covered under this. Placement of the child for adoption or foster care is another reason. Not a lot of employees realize that they can take this time off for an adoption or a foster care placement, but they can. And then also a qualifying exigency relating to active duty service in the armed forces gives an employee time off. Not all employees qualify for this. Sick leave is anyone who has worked 30 days in the calendar year. Sick leave can be used after 90 days. So once the employee has worked 30 days, they qualify, and you should consider technically it accrues from the beginning. So if you're expecting them to work 30 days, they get the sick leave. Whereas this is much more restrictive. The employee has to be employed for at least 12 months on the date the leave commences, not consecutively, but during the past 7 years. And the employee has to be employed for you for 1,250 hours during the 12-month period immediately preceding the commencement of the leave. There's an exception for pregnancy because an employee could have time off for pregnancy disability leave. That doesn't disqualify them for receiving their baby bonding time. CFRA can also be taken for designated persons. It's the same criteria as the sick leave law. They were both added into the law at the same time. Employees do have to receive notice of their right to take California Family Rights Act leave. There is a form built into the statute as a sample There's a lot of products online that create forms. I have my own set of forms I prefer. The employee has to receive notice of their rights and whether or not you've approved the leave and you've designated it. There is a risk that if you don't designate the leave, that then later the leave goes on and on and on, and you want to end it, that prior undesignated portion might not count against the total 12 weeks. So if you want to limit your employees properly and not have a claim that they didn't receive notice of their rights, you need to provide this designation form. I said this in the last webinar, and I would recommend it for this as well. The California Chamber of Commerce products are pretty good and have nice, easy to use forms. Okay. So the other thing about California Family Rights Act is it has a whole scheme built in, because it's a longer leave. There's a whole scheme built in for obtaining medical approval for the leave because it is for a serious health condition. So there's a form that you can provide for a certification for the healthcare provider to fill out. And this can be filled out by the employee's doctor if it's the employee's leave of absence, or if their mother is undergoing surgery, you take it to mom's doctor and they fill it out and certify that mom needs this particular employee to help take care of them. So you'll want to be sending these out promptly so that the employees can get them back to you. And sometimes every so often, every so often the employee does not, their story about what they need time off for doesn't always match up with what their doctor thinks they need time off for. So these forms are helpful and you get to follow what the doctor says. There's also a process for a second opinion that's far more complicated, and you would want to consult counsel for something like that. The Family Medical Leave Act under federal law is limited to a 75-mile radius where you have 50 or more employees. It's the same qualifying events as CFRA, but it includes military caregiver leave. It excludes pregnancy. CFRA excludes pregnancy, and CFRA allows both parents to take 12 weeks of baby bonding, whereas under federal law, you can reduce, if you have two parents that work for the same employer, you can reduce one of their time off. Any questions about California Family Rights Act leave or Family Medical Act leave? The most common problem I see with those, they're not paid, so we don't have pay issues, but I don't see employers giving out the certification forms and completing them when they are supposed to. So that's the big one that you want to do on those. Spot them and then give out the designation forms. There's also a state pamphlet that can be given out as well. Pregnancy disability leave. This is separate in California because we have a separate pregnancy disability leave law. It applies to all employers with 5 or more employees. All female employees are eligible up to 4 months for pregnancy-related disability. So that is a period of time in which the doctor says that the woman should not be working or has to have some job accommodations because of the pregnancy. It can include morning sickness, prenatal care, postpartum issues, or the end of pregnancy health issues. And it's a guaranteed reinstatement to the same position the employee left. There's a little chart. Let's see if I can remember how I wrote it. So for example, an employee could take 2 weeks off at some point in the year for ankle surgery. So that's 2 weeks of CFRA leave used up for a severe medical condition because they were in the hospital for that, let's say. I don't know, now they get people out of the hospital so quickly, but we'll say it counted. So now they have 10 weeks of CFRA leave left. They have a very standard pregnancy, and they are put off of work 2 weeks before the baby is born due to some issues. And then they have a 6-week recovery period for a natural birth. So they have 8 weeks of PDL, paid pregnancy disability leave, that they use. So they now have used 10 weeks of job protected leave in the year. After they recover from the birth, their doctor releases them to return to work, they can then immediately turn around and use their baby bonding leave. And since that's covered under the CFRA, they have 10 more weeks to use that. And so total, we can have a lot of time off for a pregnant employee. And this is for a healthy pregnant employee. Pregnancy disability leave is up to 4 months. So if you have multiples or any kind of complications, the employee can end up being off for the full 4 weeks plus 10 weeks. Postpartum depression also qualifies. So that can also extend the pregnancy disability leave portion quite long if the condition is debilitating for the employee. Oh, I have a little note here. There was a change in 2025. We used to be able to require employees to use up to 2 weeks of accrued vacation before they could receive paid family leave benefits. Paid family leave covers the baby bonding or the care of a family member. That's no longer the case. So take that out of your payroll policies and update your employee handbooks. The disability through EDD and the paid family leave also administered through EDD. They don't provide job protection. So employees can become confused because paid family leave is up to 8 weeks. And so they think that they have another guaranteed 8 weeks off, but it could be that they don't because maybe they didn't qualify for California Family Rights Act leave because they didn't work the required number of hours. They're not guaranteed that 8 weeks off. They have available pay, but only if you decide to actually give them the time off. Disability can run up to a year in California. And then also, I lost my train of thought. Both baby bonding can be taken and paid, and disability leave for pregnancy can be taken in chunks. They don't have to be taken all at once. Or in increments, I guess is the right word. Any questions on those? I know we had a lot of questions a few years ago when CFRA started applying to everyone, but less now. Disability leave, I think we'll go over this in next week's webinar more, but one of the biggest questions I get is the employee is performing poorly and now she is pregnant. Can I discipline her? Do I have to hold her job if I was going to fire her anyway? Or while the employee is gone, someone else is performing those job duties and some performance issues come to the surface. Reports weren't filed, things weren't done, and you don't want that employee back because you've discovered that they weren't doing their job. So that's the most common question I get with pregnancy, other than like, how much do we have to give? There's also a pregnancy disability leave designation forms that you would want to use as well, and be very clear to the employee how you are counting each of those things so that they are aware when time runs out. And you can request medical notes for that, of course. That then leads into, we're kind of going through this timeline. First, you have, your CFRA leave for an unpregnancy purpose. Then you have your pregnancy. Then you have your baby bonding. But then maybe you have postpartum depression that runs out the 12 weeks. Then the question can be, I'm now disabled under the Fair Employment and Housing Act or the ADA. Can I have more time off? And that's a separate inquiry under a separate set of laws. The Americans with Disabilities Act and the Fair Employment and Housing Act protect both applicants and employees who have an impairment that makes performance of a major life activity difficult, or who are regarded as having such an impairment. So even if their doctor doesn't say they have that impairment, if the employer just assumes they do, they're also protected. It does cover injuries covered by workers' compensation. So if you have a workers' comp claim, you have to follow those laws, but you also have to make sure you're following these. Sometimes an employee will be declared totally disabled under the workers' compensation law. That's a determination about what kind of benefit they receive. It's not a directive to an employer about whether they have to accommodate them and allow them back into the workplace. So, just know that these laws apply to your injured workers who are injured at work. It includes conditions that don't have present symptoms, but that do have symptoms that come up, maybe epilepsy that's well controlled, for example. The cause of the symptoms is irrelevant. If the employee did something that you find to be stupid or foolish and got themselves injured to the point where they're disabled, they are still covered by the law. Substance abuse can be a disability if the employee is sober at the time. Multiple minor impairments can rise to the level of a disability when they're combined. So the symptoms may be minor, but the total level impairs a major life activity. And it could include also a person who had a record of a limiting impairment. So maybe they had an impairment in the past and you don't want to put them into a job or for whatever reason. They could still be protected as a disabled worker. This covers all of these different things. Mild and temporary conditions, predispositions, personal traits, pregnancy complications could be a disability. We saw, during COVID-related symptoms can be a disability. So if an employee comes to you and says, I have a disability, or not even uses those words, but says, I have this condition that's going to impair my ability to perform my job, that's when you need to start considering whether or not you need to accommodate that employee under the Fair Employment and Housing Act or the ADA. They don't have to come to you necessarily either. If you have an employee that you can observe has a disability, if they roll up to the front door in a wheelchair, they do not have to ask for the ramp. You have to provide it. Okay. So I thought I had one more slide on this. The obligation to accommodate an employee under the disability leave laws is whether or not doing so creates an undue burden on the employer. So if an employee, we're talking about leaves of absence now. So if the employee comes to you and says, I need additional time off because I have a disability, they don't have to tell you what the disability is. You can give them the disability form and say, please take this to your doctor so we can have some additional information. It's a form that asks the doctor to state without providing the diagnosis if this person is disabled, and then compare the job duties that they have. You can provide a job description and then provide with you a more specific explanation. Does the employee really have to be off work? Or could they maybe work from home? Or could they maybe work part-time? And so it asks the doctor to give you more information so that you can engage in an interactive process with the employee to determine whether or not you can accommodate them without creating an undue burden on the business. Undue burdens can be financial. If it's a high-level position, it's possible that you could not find a replacement. You're not necessarily going to be able to find a temporary CEO, right? And that could be devastating on the operations of the business. If you have a very small business, giving leaves of absence creates more of a financial hardship sooner. If you are a large national, multinational corporation, and this person is one of 1 million call center employees, providing a very long leave of absence is probably going to have no impact on business operations. So it really just depends on that person's position and the resources that the company has. Significant negative impacts on other employees is one thing that can be considered. If you can't find a temp or you can't afford a temp and other employees are not able to cover the absence, then that is something that would give you reason to want to deny that leave of absence and hire a permanent employee to fill the position. Okay, there's some questions, and one of them is going back to the last section. Okay. Hi, Shannon. My question is, do we have to keep the employee's same job if they are out longer than 12 weeks under CFRA? No, so CFRA, if so under the pregnancy disability leave law, it's almost an automatic return to the original position. CFRA can be a return to a comparable position, comparable in pay, comparable in duties, but maybe slightly different. The best case scenario is always returning the employee to the original position. The Americans with Disabilities Act does not require you to return the employee to the exact same position either. So there's a couple reasons that you wouldn't have to in any case. If the job is eliminated, if you restructure and you eliminate that employee's whole department, and you decide we are no longer going to do our own sales, we are cutting our whole sales team and we are going to hire another company to do our sales and marketing, then you can terminate employees even while they're on their leave of absence. They finish out their disability leave and then they become eligible for unemployment benefits. You would terminate them and they would continue to receive disability benefits from the state until they were healed and their doctor released them to return to work, and then they would qualify for unemployment. And disability accommodation kind of goes in tiers. So if you can't accommodate the person in their current position, is there another position you could transfer them to where you could accommodate them at the same pay rate, same responsibility level? Or if absent that, is there a lesser position that you could put them in? And you would present them with the options for alternative positions, and then that would be part of your interactive process. I have a sample of the disability form. If you are one of my clients, I have a sample of the disability form. Just shoot me an email. If you are not, again, I recommend the Cal Chamber products, but there's a lot of other types of products that you could use. What you're looking for is to make sure it's California compliant. There are a lot of federal forms online and payroll companies that are providing you with the federal forms. Those are allowed to ask the specific disability. And in California, we don't do that. So you want to make sure you're using a correct form. If a person is out on a disability and they come back, can their position be given to someone else? So if they are out because of a pregnancy related disability, no. If they are out for some other type of disability, and they've exceeded the 12 weeks of CFRA, then it becomes less of a black and white question and more of an interactive process. Because if the employee can't perform the essential functions and you can't hold the job for them, are there other alternatives that keep this person gainfully employed? It's kind of the process you're going for very generally. When we get into terminating employees who are on disability leave or moving them into less favored positions as a last resort, those are the more risky decisions that you're going to make. That's when you may want to consult with counsel and go through all of the specifics about that employee and your workforce. It's hard to answer more specifically here today. Okay. Crime victims leave. We had for years leave for victims of domestic violence, sexual assault, and stalking, and that has been expanded. The new law was AB 2499. It went into effect on January 1st, and it protects victims of violent crimes, including, but not limited to, domestic violence and stalking. A qualifying act of violence includes domestic violence, sexual assault, or stalking, and an act, conduct, or pattern of conduct that includes bodily injury or death to another, brandishing, exhibiting, or drawing a firearm or other dangerous weapon, or a perceived or actual threat to use force against another to cause physical injury or death. And this is coming, I think it relates to a lot of different things, including violence in the workplace. You don't want, you want to be able to give leave to someone who has someone threatening them, who might then threaten others in your workplace. So it's addressing that. And then also individuals who are trying to protect themselves from violence are now being protected better in California because they can take time off to do that. They can take time off for themselves, if you're any size, to attend judicial proceedings or to obtain necessary relief, such as obtaining a restraining order. If you have 25 or more employees, they can take time off to seek relief or other services for a family member who is a victim. And they can use sick leave, like we said. And you have to accommodate crime leave victims now. I've added this section to the handbooks I've updated. You want to definitely update your handbook to include crime victims leave as it was amended this year. And you want to add the accommodations. So you, as an employer, could be required to implement safety measures, which could be a changed work telephone number, for example, or permission to carry a cell phone at work if someone was being stalked. A transfer or reassignment to a different position where maybe the person threatening them doesn't know where they are, a modified schedule, a changed workstation, installation of locks to reduce access to certain areas of the workplace, and then assistance in documenting any violence that occurs in the workplace to help that person then gain whatever relief they needed. Here's my action item, is to update your handbook. Okay, we have a few more minutes. I'm going to go through other less common types of leave just very briefly. Organ and bone marrow donation is here. 5 days of paid time off for bone marrow donation, 30 days subsequent to that unpaid time off. Very uncommon, but it happens, and employees are, very generous sometimes. So. Religious accommodation is for time off for religious events or observations. Then you have to accommodate these, much like disability, unless it creates an undue hardship, and the duration and timing is controlled by the religious observance or practice. Military leave provides up to 5 years of time off cumulatively to perform military or reserve duties for enlisted service members, and it provides guaranteed reinstatement. This is a very strict law, and I do see people mess this one up. So if you have an employee taking time off for military service, I see problems where they keep saying, I'm about to get my orders, I'm about to get my orders. You need to obtain copies of those orders once they actually receive them, and then grant them the time off. And then you need to receive documentation that they were actually cleared from their service and returned to work. And they have to be reinstated to their job. California military leave covers members of the Reserve Corps who have other military obligations. It's 17 days of leave for private employees and 180 days for public employees. Spousal military leave is only if you have 25 employees. It covers spouses of members of the Armed Forces, National Guard, or reserves who are working at least 20 hours per week. The employee is working 20 hours per week, and it allows up to 10 days of leave. Reserve emergency personnel has more obligations if you have 50 employees, but it allows time off for employees who are required to respond to an emergency duty, and 14 additional days for training if you're larger. Civil Air Patrol is employees who are responding to an emergency operations mission of the California wing of Civil Air Patrol, and that's up to 10 days per year. The employee has to have worked for you for 90 days. Drug and alcohol rehabilitation leave is for employees with 25 or more employees. This can also overlap with disability leave, so you want to be careful with that. But this one specifically covers voluntary enrollment in a residential drug or alcohol rehabilitation program. And the time off is the time necessary unless it creates an undue hardship. And this differs from disability accommodation because disability accommodation doesn't cover active addiction. School discipline applies to all employers, and it allows employees to take time off to respond when the school calls them to respond to child discipline. The Family School Partnership Act is for those with 25 employees. If you have employees in daycare or K-12, they can take time off to participate in school or daycare activities. You can require them to use their vacation or PTO. You can't require that they use sick leave, but they could if it related to preventative care. Employee literacy is another time off to enroll in adult literacy education assistance programs. And it's for those with 25 or more employees, and it's reasonable time, maybe to leave work early or to take a little bit longer lunch to allow someone to attend a literacy program. Does school discipline apply to daycare? I don't think so. I'm not 100% sure, but I don't think it does. It's for older children. Daycare, we think of like preschool age. Is giving blood the same as organ donation? No, it's not. That's not covered. I mean, any of these things you could voluntarily cover. If you wanted to give people time off unpaid to donate blood, we see employers doing that a lot in times of crisis. You can always give more, but the law doesn't require it. How often can an employee take off for school discipline? I know there's limits, and I don't know why I didn't put them on the slide. I can't remember off the top of my head. If you email me, I can look that up for you, but I'm sure that you may be able to find it as well, but let me know. Yeah, I can't remember. Drug and rehabilitation leave is not paid unless they're able to use some other kind of leave that you have that is paid, like sick leave, or I think it would qualify as preventative care. And then if you had vacation or PTO, of course. Oh, one of our participants says 40 hours per year for school discipline leave. That sounds right, but I can't remember. Literacy time. Oh, time off to vote is limited. Only if the employee is unable to otherwise vote because of their work schedule. So if you are in a location where a polling place is not open because during the employee's off time, you have to give them time to vote up to 2 hours. And that could be like at the end of the day, they could leave early, for example. I don't know how this factors in now that we have mail-in ballots so easily available. I haven't seen an update on that, but I think you have to allow them to go to the poll in person if they want to. A jury and witness duty. Like I said, jury duty is for the employee to show up and attend. They can stay if they want. You don't have to pay it. Most employees who aren't receiving pay don't want to or can't afford to serve on a long jury. And witness duty as well. If the employee has been subpoenaed to attend a court proceeding, you have to allow them to attend, but you don't necessarily have to pay them. Bereavement leave was added a couple of years ago. 5 days of bereavement leave following the death of a family member. State employees receive 3 paid days and 2 unpaid days. It applies to everyone with 5 or more employees. The employee has to have been employed for 30 days to be eligible. This isn't paid unless you want it to be paid if you're a private employer. There's an exception for those with collective bargaining provisions that cover bereavement leave. And the leave has to be completed within 3 months of the death, but it doesn't have to be used consecutively. So they could take time off a day or 2 when they first receive notice, and then a few more days subsequently to travel for a funeral, for example. And you can request evidence of the death. Reproductive loss leave was then added the next year. And this is it's very much like bereavement leave. And it's to allow an employee to take up to 5 days of leave following a failed adoption, failed surrogacy, miscarriage, stillbirth, or unsuccessful assisted reproduction. if the person would have been a parent, but for the loss. They can take up to 20 days per 12-month period. It doesn't need to be taken consecutively, but does have to be taken within 3 months of this. Oh, that was just stuck in there randomly. I wondered where that was. I was looking for it while I was preparing, and I couldn't find my title sheet. Vacation and PTO, just very briefly, we're running out of time. Time off for personal reasons and recreation that's not otherwise covered. It has to be paid out when the employee leaves your employment. So if they have a balance, they have to be paid it, and it's at their then current rate of pay. We do see this sometimes not being done. If it's not, some employers will pay it out every year so that it's being paid at that rate rather than at some subsequently higher rate, or just because that's what their employees prefer. But if you're going to roll over vacation, you either have to pay it out or you have to roll it over. And if you are rolling it over, the employee has to be able to accrue a balance that's up to 1.5 times their annual allotment. So if I allow 1 week of vacation, then the employee has to be able to accrue up to 7.5 days as their max. Once they use some, then they can start accruing again, but you can cap it. Okay, and then state wage replacement benefits. Disability insurance is available, paid family leave, unemployment, paid sick leave. Some local governments, I didn't mention this at all, but have their own sick leave with their own rules. If you're operating in other cities, you want to be aware of this. And I don't think that list is updated now that I think about it. I didn't look that up. It's expanded since I originally drafted this slide a couple of years ago. I pulled this from another presentation. Workers' compensation, also available if it's a work-related injury. And so I have more questions. That's my last slide. There we go. I will send out the slides to those of you who attended, and I will post the video on my website and send you a link to it through, I'm using Ring Central, so send you a link to that. If you're an attorney and you want MCLE credit, I can provide that through my firm, but you need to email me so that I know that you want it and that you were in attendance. Let me see if I have any other questions. Oh, religious accommodations. Can you require advanced notice of a particular amount of time? The Fair Employment and Housing Act is what provides the accommodations for religion, and it doesn't have specific notice provisions built into it like some of the other laws do. But you can require an employee to give you reasonable notice if they were aware of it in advance. And if it's a religious holiday, then they should have notice of it very far in advance. Sometimes there are religious practices that occur around deaths or other things that pop up and that they don't have as much notice of. That would be kind of as soon as practical, the employee could be asked to give you notice of that absence. Now, what if they don't? Can you deny it? That's a question I think that's more specific and that needs to be discussed with your attorney, because it's not like some of the other leave of absence laws where it's spelled out very clearly. Okay, I don't have any other questions. Does anyone have any other questions? You can always email me. I'm happy to answer questions about the presentation after. Oh, hi, Anna. It's good to see you. And Carrie, hello. Okay, great. I'm not seeing any other questions, so I'm going to go ahead and sign off. And hopefully you found this helpful. Hopefully you join me for next week's webinar as well. I'll see you next Friday. Thank you so much.